Some Supreme Court decisions are wrong because they misapply a constitutional principle. Others are wrong because they prevent that principle from developing at all. In 1873, only 5 years after the 14th Amendment was ratified, the Supreme Court decided the Slaughterhouse cases. By a vote of 5-4, the court interpreted one of the amendment's most important protections, the Privileges or Immunities Clause, so narrowly that it has remained largely dormant ever since. The court's decision did more than uphold the Louisiana slaughterhouse monopoly. It deprived the 14th Amendment of what may have been its most natural textual protection for civil rights, economic liberty, and the freedom to pursue a lawful occupation. And it forced later courts to protect many fundamental rights through a far more controversial doctrine, substantive due process. Welcome to the classical liberal Constitution, where the Supreme Court got it right and where it got it wrong. In this episode, we examine why the Supreme Court got the slaughterhouse cases profoundly wrong. The story begins in Reconstruction-era Louisiana. In 1869, the Louisiana legislature created the Crescent City Livestock Landing and Slaughterhouse Company. The law gave this private corporation the exclusive right, for 25 years, to operate livestock landings and slaughterhouses throughout New Orleans and the surrounding parishes of Orleans, Jefferson, and St. Bernard. Other butchers could continue performing the physical work of slaughtering animals, but they were required to do so inside the corporation's facilities and pay the fees established by law. Independent slaughterhouses throughout the designated area were ordered to close. The exclusive territory covered more than 1,000 square miles and contained hundreds of thousands of people. Louisiana defended the law as a public health measure. The legislature had legitimate reasons to address the location and sanitation of slaughterhouses. Animal waste and contaminated water could create serious health problems in a growing city. The state could therefore require inspections, establish sanitation standards, and move slaughtering operations away from densely populated neighborhoods. But the law did not merely regulate where animals could be slaughtered. It granted one favored corporation an exclusive legal privilege and forced approximately 1,000 working butchers to conduct their trade through that company. The question was whether a state could use its police power not merely to regulate a lawful occupation, but to place that occupation under the control of a government-created monopoly. The butchers challenged the monopoly under the recently ratified 13th and 14th Amendments. Their most important argument relied on this language: no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. That clause appears immediately after the amendment establishes national and state citizenship. The butchers argued that the privileges or immunities of American citizenship included the right to pursue a lawful occupation without being arbitrarily excluded for the benefit of a politically favored corporation. That argument fit naturally within a classical liberal understanding of citizenship. A free citizen is not merely someone whom the government declines to imprison. Citizenship includes the ability to own property, make contracts, earn a living, seek legal protection, and pursue lawful work on equal terms with others. The Civil Rights Act of 1866 had already identified the rights to make and enforce contracts and to purchase, lease, sell, hold, and convey property as central civil rights. The legislation was enacted primarily to secure equal citizenship for formerly enslaved Americans, but it demonstrates that the Reconstruction generation understood contract and property rights as essential components of freedom. The butcher's argument, therefore, did not require the court to invent an unfamiliar conception of liberty. It required the court to take seriously the constitutional language that had just been added to protect the rights of American citizens against state abridgment. Justice Samuel Miller wrote the majority opinion. Miller correctly recognized that the Reconstruction Amendments had been adopted in response to slavery and the continuing oppression of formerly enslaved people. He described the freedom and protection of the formerly enslaved population as the amendment's one pervading purpose. But the majority then used that history to support an extraordinarily narrow interpretation of the Privileges or Immunities Clause. The court distinguished between citizenship of a state and citizenship of the United States. It held that the clause protected only rights arising specifically from national citizenship, rights connected to the federal government, federal law, or the nation's existence. Ordinary civil rights, including the right to pursue a lawful occupation, were classified as privileges of state citizenship. According to the court, those rights remained almost entirely under state control and received no additional protection from the Privileges or Immunities Clause. The majority offered a limited collection of rights that might qualify as privileges of national citizenship. These included access to federal institutions, protection from the federal government while abroad, use of navigable waters, habeas corpus, assembly, and rights secured by federal treaties. But the basic rights of everyday citizenship, the rights to work, contract, own property, and pursue a livelihood, were excluded. Under this reading, Louisiana could regulate the butcher's occupation and favor one corporation over the others without violating the Privileges or Immunities Clause. The court also rejected the butcher's arguments under the Due Process and Equal Protection Clauses and upheld the monopoly. The majority was concerned about federalism. Justice Miller warned that the butcher's interpretation could transfer the protection of nearly all civil rights from the states to the federal government. Federal courts might become permanent supervisors of ordinary state legislation, and Congress could gain extensive authority to enforce individual rights against the states. Miller believed that such an interpretation would fundamentally alter the relationship between the state and federal governments. He doubted that Congress or the ratifying states had intended so dramatic a transformation. That concern should not be dismissed. The federal government possesses only the powers granted to it by the Constitution. The 14th Amendment should not be treated as a general license for federal judges to review every state policy decision or substitute their preferences for those of elected legislatures. But the majority's answer confused two very different ideas. Protecting constitutional rights against the states does not give the federal government complete authority over state policy. The Constitution can forbid states from abridging fundamental rights while leaving states with enormous authority over criminal law, property rules, public health, education, local government, and countless other matters. Every constitutional right limits democratic choice. That is the point of having a written constitution. The question is not whether the 14th Amendment changed federalism. It plainly did. The question is how it changed federalism, and the amendment's text directly prohibits states from abridging the privileges or immunities of American citizens. The majority's interpretation created an even deeper problem. The limited national rights recognized by the court were generally already protected against state interference by the Constitution's supremacy over state law. A state could not lawfully obstruct federal institutions, interfere with federal treaties, or prevent the exercise of federal authority even before the 14th Amendment was ratified. If the Privileges or Immunities Clause merely repeated those existing protections, it accomplished very little. Justice Stephen Field identified this problem in dissent. He argued that if the clause protected only rights already secured by the federal Constitution, it became essentially a vain and idle enactment. The Constitution did not need a new amendment merely to restate that federal law was supreme. The majority's reading, therefore, violated an elementary principle of constitutional interpretation. Constitutional language should ordinarily be interpreted to perform meaningful work. The people had just ratified a provision prohibiting states from abridging the privileges or immunities of American citizens. The most natural inference is that the provision added a genuine new protection against state action. Justice Field viewed Louisiana's law as a classic example of arbitrary class legislation. He accepted that the state could regulate slaughterhouses to protect public health. Louisiana could inspect animals, impose sanitation requirements, and require slaughtering to occur outside heavily populated areas. But Field distinguished regulation from monopoly. The state could determine where the occupation was conducted without granting a private corporation exclusive control over it. In his view, the sanitary justification was being used as a pretext for transferring a right previously enjoyed by many citizens to a small, favored group. Field argued that the right to pursue lawful employment was among the fundamental privileges of free citizenship. The government could impose regulations that applied equally and genuinely protected the public, but it could not arbitrarily prohibit ordinary citizens from conducting a lawful trade so that a politically connected corporation could enjoy an exclusive advantage. That position was not simply pro-business, it was anti-monopoly. A classical liberal constitution should be suspicious not only of government hostility toward private enterprise, but also of alliances between government and favored private interests. Economic liberty means the freedom to compete, not the entitlement of an established corporation to use state power against its competitors. Justice Joseph Bradley offered an even broader defense of constitutional liberty. Bradley argued that citizenship was not an empty title. It carried fundamental rights, including the ability to acquire and enjoy property, seek legal protection, and engage in lawful employment. He described the right to choose one's calling as an essential element of freedom. Without the ability to select and pursue an occupation, he reasoned, a person could not truly be a free man. Bradley did not claim that occupations were immune from regulation. He recognized that government could adopt lawful rules necessary for the common good. But regulation had to remain regulation. A state could not destroy the liberty of an entire class of citizens by giving their occupation exclusively to someone else. His distinction remains crucial. There is a difference between requiring every butcher to comply with legitimate sanitation rules and requiring every butcher to become economically dependent on one government-selected corporation. One protects the public, the other distributes economic privilege. The Privileges or Immunities Clause has never fully recovered. The Supreme Court has occasionally used it, most notably to protect the right of newly arrived residents to receive the same treatment as other citizens of their new state. But the clause continues to play only a minor role in constitutional law. When the Supreme Court considered whether the Second Amendment applied to state and local governments in McDonald versus Chicago, the challengers asked the court to reconsider Slaughterhouse and apply the right through the Privileges or Immunities Clause. The court declined to do so. The majority applied the Second Amendment through the Due Process Clause instead, while Justice Clarence Thomas argued separately that the right should be protected as a privilege of American citizenship. The constitutional structure created by Slaughterhouse, therefore, remains with us. A clause expressly protecting the rights of citizens does very little, while a clause referring to due process performs much of the substantive work. That arrangement is difficult to defend as a matter of constitutional text. The Slaughterhouse cases presented a genuine public health problem. Louisiana had constitutional authority to regulate slaughterhouses, protect water supplies, inspect animals, and remove dangerous facilities from crowded neighborhoods. But the police power is not the power to create private monopolies whenever government can identify some legitimate regulatory objective. The state could have protected public health without transferring an entire lawful occupation to a favored corporation. More importantly, the Supreme Court could have upheld meaningful state authority without reducing the Privileges or Immunities Clause to near irrelevance. A better decision would have recognized three principles. First, the rights to work, contract, own property, and pursue a lawful calling are privileges of free citizenship. Second, states retain authority to regulate those rights for legitimate public purposes. Third, courts must distinguish genuine regulation from arbitrary exclusion, class legislation, and political favoritism. The 14th Amendment was not adopted merely to repeat protections that already existed. It was adopted because state governments had demonstrated that they could not always be trusted to respect the rights of their own citizens. Its text therefore placed certain fundamental rights under national constitutional protection. By refusing to give that language meaningful effect, the Supreme Court did not preserve the 14th Amendment. It disabled one of its central protections. And that is why, in the Slaughterhouse cases, the Supreme Court got it wrong.